Officer Dave, would you open the courtroom, please? What? All right. 36th District Court is now in session. Judge David Robinson presiding. Find out who we have here.
Hello.
Hello.
Mr. Ingbar.
Yes, it's Kyrie Craig. Good
It's
morning.
Mr. Sims. Yep.
Mr. Ingbar,
Yes, I'm sorry.
what case brings you here?
19-169-584.
Wendy Mays here.
Yes.
Fine.
All right, everybody else is going to the waiting room.
All right. This would be Sims. I'm going to the waiting room.
Thank
Right?
And my name is Kyrie Craig. I was unable to find an attorney, so I'm
Going to the waiting room.
Pardon me.
Wait until I call your case, please.
Okay.
All right. This is Michigan Education Association versus Wendy Mays. Give me just a second to locate your file. We can get started. We are on the record calling file number 19169-584. The file is entitled Michigan Education Association versus Wendy Mays. Date and time for objection to garnishment. Your respective peers.
Paul Ingber, appearing on behalf of the plaintiff. My bar number is P22976.
What is your name, ma'am?
Wendy Mays.
You are the moving party. What is the basis of your objection to garnishment?
I was not notified of the debt. I have not, they were sending, the address that they had for me, which was 10122 Violet Lawn.
Ma'am, turn down your volume, please.
Okay. Is that better? Then I won't be able to hear you.
Oh, go ahead, ma'am.
I said the address that they had for me was 10122 Violet Lawn, which I have not lived at that address in well over 30 years. Was not notified of a debt at work or by any other means. I'm still at the same place of employment. And even I filed bankrupt in 2012 and that debt didn't show up then either. So I was unaware of the debt.
Mr. Ingber, your response.
My response is that we show that she was personally served at the Violet Lawn address, which is 10122 Violet Lawn in Detroit. I do have information that she was using that address back in 2019.
That's so much.
Which is when this service took place. And in addition, Your Honor, the defendant hasn't raised a meritorious defense to this matter. And the judgment was entered back in 2019. It's almost just over a year and a half old now. I would ask that the court deny her request for relief.
Is there anything else you want to tell the court?
Your Honor. I can't hear y'all.
Ma'am, is there anything
Your
else you want
Honor.
to tell the court?
I can't hear you. Is there what?
Is there anything else you want to say?
Yes, there is. I have to put my headphone back on. Yes, there is. That is not true, and I swear I have never been personally served by anyone. And if you look here at my W-2 form, it has my address on Fontana Drive in Southfield, where I have been residing since 2008. I have all of these W-2 forms. This here is 19. It goes all the way back to 15 because that's as far back as I could go. And there have the Fontana address on it. My mother purchased that house. That was my mother's home on Violet Line. My mother passed in 2004. So there's no way I would even be at the Violet Line address. It's not true.
All right, thank you. Court's prepared to rule. Ma'am, Michigan Court Rule 3.101K specifically provides may not use the objection to garnishment form to challenge the validity of the judgment. Having failed to state a valid objection to garnishment, the objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected in 21 days from today in the Wayne County Circuit Court. Thank you both for coming.
Does it matter that he lied and said that that I was personally served? That is a lie.
Ma'am, as I told you, you may not use the objection to garnishment form to challenge the validity of the underlying judgment. That's what we have before the court today. Thank you for coming in on the record.
Thank you, Your Honor.
Today, 21 days from today, expect your appeal in the Wayne County Circuit.
Okay, thank you.
Mr. Eckelberry, good morning.
Morning, Your Honor.
Who is your opponents?
Brian Robillard.
I don't see Mr. Robillard here. I'm afraid I don't have Mr. Robillard as of yet. So back to the waiting room you go.
Okay.
Good morning, Ms. Dixon.
Good morning, Your Honor.
Who are you representing today?
I'm actually here for two cases. So
Okay.
they're both for Ford Motor. So the first case is 02144145GC. It's
That's
against
Jeremy Richardson.
Yes.
I have Mr. Richardson. Let's do your case next.
Okay, thank you.
02. All right, we are on the record calling file number 02-144145, Ford Motor Credit versus Jeremy Richardson. Your appearances.
Good morning. My name is Natasha Dixit. I'm the attorney on behalf of Ford Motor Credit Company, LLC. My P number is 82333.
What is your name, sir? Sir, what is your name? You need to unmute yourself. Sir, you're muted. Unmute yourself.
Sorry, can you hear me now? I'm
Yeah.
sorry.
What is your name, sir?
My name is Jeremy Richardson.
Mr. Richardson, you are the moving party here at this objection to garnishment. What is the basis of your objection to garnishment?
Your Honor, I was never even notified of this writ.
Notified of what, sir? Garnishment?
I mean, I would, you know, I would go into some sort of an agreement with Ford Motor Credit to pay this. Frankly, I haven't seen anything about this in years. You know, I can pay him, you know, go into an agreement, but I can't really afford to have 25% of my check garnished.
All right. Do you have any other basis for your objection to garnishment? And I know for the record, 25% is the maximum amount allowed by law for garnishment. Do you have any other basis for your objection to garnishment, sir?
The amount of the judgment is in dispute. I mean, I don't agree with that either. And there's another opportunity. I'm hoping to, you know, have a motion to have a conversation with the court about that.
That motion is not before me today. Do you have anything else you want to say in support of your objection to garnishment?
No, sir.
Your response, Counsel.
No, Your Honor. Just because Mr. Richardson, we just don't think he has a valid basis to set aside the garnishment, because this was a wage garnishment, and it is the employer's duty, the garnishee's duty, to serve a copy of the garnishment on the defendant, Mr. Richardson. So we do request that the court deny Mr. Richardson's objection to the garnishment.
All right. The court had an opportunity to review that. Mr. Richardson's stated basis is that he was not advised of the notification of the writ of garnishment. The obligation to notify you, sir, of the writ of garnishment does not belong to the plaintiff, but belongs to the garnishee defendant. That is your employer. The way the process works is that the writ of garnishment is served on that employer. That employer does two things. They file a disclosure that says, yes, I have some money that belongs to Mr. Richardson, or no, I do not. It's their obligation to tell you that you have been garnished. 25% that you claim has been garnished is what is committed by law. Having failed to state a valid objection to garnishment, your objection to garnishment can be denied. You, of course, sir, have an absolute right to appeal my decision. That appeal must be respected in 21 days today in the Wayne County Circuit Court. Thank you for coming in, sir. I'll send out a notice to you both today. We are off the record.
You turned your head. I didn't hear what you said. So.
I denied your motion. Writ of garnishment.
So,
The government of garnishment. You want to know what I've said? I'll say it again.
okay.
The obligation to notify you that you've been garnished belongs to the garnishee defendant. That is your employer, not to the. We'll send out an order for 21 days to appeal my decision. We are off the record. Ms. Dixit, you had another one, Catherine.
Yes, Your Honor, that is correct. So the other case is for Ford as well. It's for Catherine Gray.
I'm trying to see if I see that name on my list of people that are here. I do not see a Catherine Gray at this point in my waiting room. I will put you there and I'll call somebody else. You go back to the waiting room.
All right, thank you, Your Honor.
Ma'am, what is your name?
Arlene Brown Jones.
I'm sorry, what case are you here on?
I asked for a hearing. It was
Yes,
case number
191622224.
Yes,
Okay, let me see if I see this precedent. Oh. Hello,
Yes.
Yes.
what is your name?
My name is Kyrie Craig.
Okay, I don't have you ready yet. I'll put you back in my waiting room. Ms. Robinson, I do not see the opponent on your case. Let me try opening the field to everybody to see if they're there.
Brown Jones.
I don't, yeah, I know your name, ma'am. I'm saying I don't see the opponent on the other side.
Okay.
Put you back in the waiting room. All right. I'm calling case number 06115174, Ford Motor Credit versus Catherine Gray. Filed here for objection to Johnson. No respective parents.
Good morning, Your Honor. My name is Natasha Dixon. I'm the attorney on behalf of Ford Motor Credit Company, LLC. My P number is 82333.
And what is your name? She's connecting the audio now. She's still connecting. Ms. Dixon, I can't seem to be connecting your audio. I'm going to put you both back in the waiting room.
Okay, thank you. Thank you, Your Honor.
Mr. Fisher, good morning. Mr. Fisher. Unmute yourself, Mr. Fisher.
My apologies, Your Honor.
What are you here for today, sir?
I'm here for case 2015796, Citibank versus Deloitte Sparrow. I'm here on behalf of Ms. Sparrow.
Okay, and you know who your opponent is today?
I'm sorry?
You know who your opponent is today?
Well, I suspect it's Craig Fay. He's who I've been.
I don't see that name here. Let me try one more time. See if I can get somebody here. Oops. All right, is there anybody here on case Citibank versus Deloitte Farrell, 201-57986.
I'm here for that one, Your Honor.
Who was I?
Brian Gruen. I should have my case number on
I
the
see
screen as
you and I
well.
see Mr. Fisher. Everybody else is back to the waiting room.
All right.
Fisher, you can stay around. Okay. We are on the record calling 201-57986 Citibank versus Deloitte Farrell. Your respective appearances, gentlemen.
Good morning, Your Honor. Brian Gruen, Gruen. P number is 56673 on behalf of plaintiff Citibank.
Good morning, Your Honor. Greg Fisher, P80885, here on behalf of Ms. Farrow.
All right, gentlemen. Is our discovery done here?
Yes.
I believe so, Your Honor.
All right. Then are either of you contemplating dispositive motions?
We had filed one previously, Your Honor, so I'm not for sure if we're going to refile that or if we're just.
Okay, well, here's what I'm going to do. I'm going to give you guys a return date. I'm going to close your discovery, and you can talk about your resolution. If not, we'll try it again the next time we're together. Does June 8 work for both of you gentlemen?
That should work for our office, Your Honor.
Yeah, that works for me.
Okay, June 8, 2021 at 10 a.m. will be our next pretrial. Your discovery is closed. Anything else we've accomplished today, gentlemen?
I believe that should do it, Your Honor.
That's good, Your Honor.
All right, so what I'm going to do is I'm going to send out an order today. You guys can talk about resolving your file. If you can't get it done, then we'll talk about it again June 8th at 10 o'clock. Thank you both for coming in.
Thank you, Your Honor.
Have a good day, gentlemen.
You too.
You have another file, Mr. Fisher, or are you done?
No, I don't. I'm on my way out here.
Okay. Have a good day. Good morning, Ms. Francis.
Good morning, Judge. How are you?
Good. How are you?
Good.
What brings you here today?
I have two this morning. I have 855 for Jefferson versus Craig.
Let me look.
I think he had said he was on the phone.
He's on the phone. You think he's on the phone?
I think so. I think he was the one calling out when you were.
Let's try that. Let's admit him and see who this person is. All right, who's on the phone at 128?
Morning, law. This call may be monitored or recorded. Can I help you?
Hello? Who's on the phone at phone number ending in 128?
Your Honor, it's Kyrie Craig.
Okay, then I have you both. Hang on, let me get your case started. I'll call you file right now. 20855. We are on the record calling file number 201-42855. The file is entitled Jefferson Capital System versus Kyrie Craig. Date and time for objection garnished. No appearance.
Good morning, Your Honor. Navjot Francis, P72322 on behalf of Plaintiff's Attorney of Record.
And what is your name, sir?
Your Honor, I don't have an attorney. I represent myself.
What is your name?
Kyrie Craig.
Sir, you are the moving party. Let us proceed with your objection to garnishment.
Yes. This account is a fraudulent account. I never lived at neither address that this Jefferson Capital Systems reported. When this was open, I was living at the current address that I have now, that I've been living on for the past 7-8 years. And I have I faxed a copy of my FTC report to Aisha Davis for proof that that is not my account. And I disputed that with all 3 of my credit bureaus and locked and froze all my credit bureaus as well.
Do you have any other basis for your objection to garnishment that you haven't told the court?
It's an objection of tax refund credit.
Yes, sir. I'm asking you if you have any other basis other than your claim that it's a fraudulent account.
Yeah. Well, I have an FTC report that I have on file, and I have proof that I have lived at this address currently when those accounts was fraudulent placed on my when that was placed. I never lived at none of those addresses.
Okay. Anything else you want to tell the court?
I also want to tell the court that it was actually fraudulent phone numbers and addresses as well. Reported on my FTC report. The phone number that was left on my Experian credit file was not, I never had that phone number. That was a fraudulent phone number as well. And another thing is, when on my Experian credit report, my first and last name was spelled incorrectly. And my social security number has been involved in a data breach. So basically what I'm saying is, this not my account. And I told Jefferson Capital this, I disputed them with this, and they just kept sending me information that because I never had this account in my name. Like, I'm not aware of this. It's a fraudulent account.
All right, your response.
Your Honor, defendant is attempting to attack the underlying judgment, which is not allowed under an objection to garnishment. And this is a tax garnishment, so only limited objections are under the court rules. So we are asking for his objections to be denied.
All right. Court has had an opportunity to hear the argument of counsel and of Mr. Craig. Mr. Craig, the court rule on this case is quite specific. Michigan Court Rule 3.101K specifically provides you may not use the objection to garnishment to challenge the validity of the underlying judgment. That is the only matter before the court. Therefore, having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You have an absolute right, sir, to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court. I will send out an order to you both today. Thank you both for coming in. We are off the record.
Thank you, Judge. I have one more.
Okay. You had another one, Ms. Francis?
I do, Judge. It is 224.
What's the person's name?
Earlene Brown Jones.
I think I've had her earlier. Let's see. What is your name, ma'am?
Earlene Brown Jones.
Yeah, okay. Let's call that case. That's going to be file number 191622224. Joseph Presti versus Earlene Brown Jones. Could I have your respective appearance?
Good morning, Your Honor. Navjot Francis, P72322 on behalf of the plaintiff.
And what is your name, ma'am?
Earlene Brown Jones.
You are the moving party. What is the basis of your objection to garnishment?
I was coming because he was taking me to court for a house that I never stayed at.
Do you have any other objections, garnishment?
Yeah, he was trying to garnish me for a place that I never stayed at. So I was trying to do objection garnishment for that.
Okay. Counsel, your response.
Your Honor, defendant is attempting to attack the underlying judgment, which is not allowed through an objection to tax garnishment. So her objections, we are requesting for them to be denied.
Ma'am, the court rule in this case is quite specific. Michigan Court Rule 3.101K specifically provides that you may not use the objection to garnishment form as a means of attacking the underlying judgment. You're saying there's something wrong with the underlying judgment because you never lived at that address. Objections to garnishment are limited to the defects in or the invalidity of the garnishment proceeding itself. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected in 21 days of today in the Wayne County Circuit Court. The court will be sending out to both of you with order today. Thank you both for coming in. We are off the record.
Thank you, Judge.
Thank you.
That's all that I have for today.
Okay, then you're done.
Thank you.
All right, Mr. Sims, let's
Yes,
find a pair. Who are you here for today?
I'm here for case 13121,
Okay,
S95.
Yeah.
Pardon?
I think I have your opponent. Let's see if we can't get you done.
Lawa?
Yep, that's the one I see.
Okay.
All right, we are on the record calling file number 131215595. The file is entitled A&A North America versus Lawa, Muhammad. Could I have your respective appearance?
Sims, Reynolds Sims, P23255 for the plaintiff A&A America.
Okay, what is your name, ma'am?
It's Lozelle Jami.
All right, you are the moving party. What is the basis of your objection to garnishment?
I'm sorry, one more time.
You are the moving party. What is the basis of your objection to garnishment?
So there was a card under my mother's name where it was used, and it was not of my knowledge that it was opened. It wasn't my mother that opened it.
Do you have any other basis for your objection to garnishment?
No.
Your response.
Your Honor, this is the response we have on the objection to garnishment is that they were never originally served. And we have attached personal service in an appearance some years ago in 2016 by the defendant to solve that problem. The fact we have now, we're challenging the judgment, which is not appropriate under the court rule. It should be by a different type of motion, and therefore, and we haven't been paid in quite some time on this, and this is a tax garnishment. And of course, they received notice of this, of course.
All right.
So, Your Honor, we therefore think that this should be denied.
All right. The court is in receipt of the pleadings here, and the stated ground from the objection to garnishment, original summons and complaint was not properly served. Michigan Court Rule 3.101K is quite specific. Objections to garnishment may not be used to challenge the validity of the underlying judgment, which is what you're attempting to do here. Now saying that the credit card was not opened by your mother. Having failed to state a valid objection to garnishment, the objection to garnishment must be denied. You, of course, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Court will send out an order denying the objection to garnishment to both of you today. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
You done, Mr. Sims?
Yes.
You have another, okay.
All right, thank you, Your Honor.
All right, sir, you're all good to go.
All right.
All right, what do we got? All right, I seem to have is Catherine Gray here. Mr. Echoberry, I have a pair that's not you. So you're back to the waiting room again. I still don't have your opponent. All right, let's call case number 06115-174, Ford Motor Credit versus Catherine Gray. Date and time for objection to garnishment. Your respective appearances.
Good morning, Your Honor. My name is Natasha Dixon. I'm the attorney on behalf of Ford Motor Credit Company, LLC. My PIN number is 82333.
And what is your name, ma'am?
Catherine Gray.
You are the moving party, ma'am. What is the basis of your objection to garnishment?
I never received the notice to dispute it.
You never received the notice of the garnishment? Is that what you're saying?
Yes.
All right. Anything else you want to tell the court?
That it's been some time and I didn't realize it was still owed.
Okay. Anything else you want to tell me?
No, except that I would like to try to pay the bill if it's valid.
All right. Let me hear from Ms. Dixon.
Thank you, Your Honor. So we do request that the court deny this objection to the garnishment because there is no valid basis to set aside the garnishment from Ms. Gray. She said that she wasn't served or it's invalid because she was not served and she does not have knowledge of this. Our office did file the garnishment with the court on November 17, 2020. And it was served on February 3rd of 2021.
All right. Problem that I have, ma'am, is I'm looking at the register of action here. You personally served with summons and complaint in this matter on April 28, 2006. Judgment was entered on June 6 of 2006. Thereafter, on August 14th of 2006, you filed a motion for installment payments. The judgment of that issue was renewed on March 18, 2016. You have failed to state a valid objection to garnishment. Your objection to garnishment must therefore be denied. The way the process works, ma'am, is that when a garnishment is filed, it is not the obligation of the plaintiff to tell the defendant about the writ of garnishment. That's the obligation of the garnishing defendant, the employer or the bank or the Treasury Department. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. We are off the record. I'll send out an order to both of you today. Thank you both for coming in.
Thank you, Your Honor.
Are you done, Ms. Dixon?
Oh, yes, I am. Thank you.
Have a good day.
You too. Thank you.
We are on the record calling file number 20163-587. The file is entitled Sierra Wright versus Mimic Insurance, Mimic Insurance Corporation. We were last together on this file on April 7th, 2021, at which time the matter was set for pretrial today, May 5, 2021 at 10 o'clock, the date and time agreed to by counsel for both sides. It is currently 10:40. Your appearance.
Morning, Your Honor. James Eccleberry appearing on behalf of Plaintiff Kira Wright, P number 78222.
Mr. Eccleberry, have you guys settled this case?
Unfortunately, no, Your Honor. As the court may recall, I communicated a settlement demand back on April 5th. I have sent a couple of follow-up emails to check on whether there's any response to my demand and haven't received a response. While I was in the court's waiting room, I did put a call into defense counsel's office and left a voicemail. And haven't received a response to my call or that voicemail or my emails at present.
All right, somebody just checked into the waiting room. Let's see who this is. Hello?
Yes, is this Judge Robinson?
Yes, who is this?
This is Robert Jones, sir. Please forgive me, but I had you on my laptop, and then everything just went bad. So I kept trying again, and then I grabbed this paper again and said, well, let me just call this number.
Okay. All right, Mr. Jones, you're not the person I'm looking for. I'll put you in the waiting room. We'll be back.
Okay, thank you.
All right, Mr. Eccleberry, we're back on your file, 20163-587. The plaintiff has appeared, the defendant has failed to appear. And no good cause of that failure having been shown, the default of the defendant is hereby entered. I look forward, sir, to your default judgment.
Understood, Your Honor.
Thank you, sir. Have a good day.
Will do. Thank you. Your Honor, briefly, is Your Honor going to set a control date for us?
What I'm going to do is I will simply send out today the notice of the written notice of the default, and I'll be looking forward for your judgment as soon as you get the response.
Understood, Your Honor.
Okay?
Okay. Thank you,
sir. Have a good day.
You as well.
We're off the record on your file. All right, we are on the record calling file number 06141121. The file is entitled Asset Acceptance versus Robert Jones. This is the date and time for the objection to garnishment. You are the, what is your name, sir?
My name is Robert D. Jones, Your Honor.
Sir, you're the moving party. What is the basis of your objection to garnishment?
Well, I was contacted by my place of employment on the 3rd, stating that they have a writ of garnishment. So I obtained the paperwork and I said, okay, well, this is from a third party. So I contacted the third party and I asked them what this was about. And they said DTE. So I said, well, DTE. I'm like, well, what year? Initially, she said 2003. I'm like, well, wait a minute, this is 2021. I said, but okay, can you give me the address? Well, no, we can't do that, sir. We don't have it. You have to contact the court, put in the case number. I did that. So now the only address that I saw was 13523 Asbury Park, sir. And I never had an outstanding bill with DTE there. So what I did next was I contacted DTE and I explained everything to the representative, even told her the year. She was like, well, do you know the address? I said, well, this is the address. She said, okay, well, hold on. What's your full name and your social security number? So I gave the representative that. Your Honor, she put everything up. She said, I don't see anything for you, outstanding bill with us, past or present. So I said, okay, well, let me do an objection to find out more about this.
Well, the problem I have, Mr. Jones, is that's not the purpose of the objection to garnishment. The objection to garnishment can be only used to challenge the validity of the underlying judgment. I mean, you cannot use it for that purpose. The only thing you can use the objection to garnishment for is to point out defects in or the invalidity of the garnishment proceeding itself. In this case, the register of action indicates you were personally served in this matter back in October of 2006. In April 17th of 2007, a judgment by default was entered against you. That judgment was renewed, judgment list for 10 years, on January 24th of 2017. You failed to state a valid objection to garnishment. The objection to garnishment, sir, must therefore be denied. You, of course, have an absolute right to appeal my decision. That appeal must be perfected in 21 days of today in the Wayne County Circuit Court. I'll send you out an order today, sir. Thank you for coming in. Have a good day.
Okay, so can I ask one more question?
Sir?
Okay, I see here that it says 1100. Now, they've already started garnishing it. Okay, I believe they take like $80 a week. And the amount, if I'm correct, Your Honor, is it $1,135.29?
That was a judgment that was entered April 17th of 2007. That judgment, sir, earns interest until it is satisfied.
Okay, so what is the total amount?
Sir, that's not before me today. You have to take that up with plaintiff's counsel.
Okay, thank you.
Thank you, sir. Have a good day. You're off. Mr. Brewer, good morning.
Good morning, Judge. How are you?
I'm not bad. Yourself?
Good. Can't complain.
You and Mr. Brunetti are here on Tasha Norwood versus Travelers.
That is correct.
All right, just call your file and get you out of here. We are calling file number 20168-566. This is Tasha Norwood versus Travelers Indemnity. Date and time for pretrial. Your respective appearance.
Good morning, Your Honor. Richard Brewer on behalf of Ms. Norwood, P31124.
Good morning, Your Honor. Ross Brunetti on behalf of Defendant Travelers, P73080.
Okay, have we gotten that half-hour deposition done?
It is scheduled for June 2nd, Judge.
Okay.
Actually, Richard, I have it for May 20th at 2 p.m.
Do you? Okay.
That's what my notice says.
Okay. Anyway, it's scheduled for, and I'll give you a pretrial date. By that time, we'll be done with it. June 8th work for both of you gentlemen?
June 8th.
June 8th.
Let me just check the calendar if I could.
If you would.
June 8th works, Your Honor.
And Mr. Brewer?
Let's see. June 8th. What time would that be, Judge?
11 o'clock like today.
I can do that.
All right, June 8th at 11 o'clock. Will be our next pretrial. And I expect all that discovery to be done.
Yes, sir.
Thank you, Your Honor.
All right, gentlemen, let's get this one done. Thank you for coming in. I'll send out an order to you both. Have a good day.
Thank you, Judge. You also.
Thank you, sir. Have a good day. Good morning.
Good morning.
I don't have your opponent as of yet, so I'll put you in the waiting room.
So we're dismissing the case. I had, my apologies for my background. I had faxed you a motion to stipulated order to dismiss, signed by both of us. We tried to fax it to your chambers.
When did you send that?
This morning.
Oh, wait.
We just,
let's see if I have it. I wasn't here when I got here. Let me look. Okay, this appears to have arrived while I was in the midst of my morning call. Let me see. Okay, let's call the file for the record. Calling case number 20164-544, Northwest Labs versus City of Detroit. Your appearance, please.
Laura Sheehan, P83327 on behalf of the City of Detroit defendant.
And what I have here is an order dismissing the cause with prejudice. It appears to have come over twice.
Yes.
And okay, so if you guys have agreed to this, and you're telling me as an officer of the court that the other side agreed to this order?
Yes, Your Honor.
I accept your representation as an officer of the court. We'll enter your dismissal. The matter is done.
How do we go about getting a copy? Do I send a runner?
We'll mail one out.
Okay, great.
We'll mail them out to the parties.
Okay, thank you so much.
Thank you. Have a good day. You're off the record.